Generally, courts are allowed to review the legality of administrative agency actions, but can Congress limit that review? If so, how can Congress accomplish that? The United States Supreme Court addressed these questions in McNary v. Haitian Refugee Center. The Immigration Reform and Control Act of 1986, also known as the Reform Act, was a federal law that, among other things, created an amnesty program called SAW, which stood for Special Agricultural Workers. Under the SAW program, an undocumented alien who had performed qualifying agricultural work in the United States could apply to have his or her immigration status adjusted from illegal to legal resident. The SAW program was administered by the Immigration and Naturalization Service, or INS, a federal administrative agency. The Reform Act had a channeling or limiting provision. This channeling provision stated that the INS's determination of a status adjustment application under the SAW program wasn't subject to judicial review unless the court was reviewing an exclusion order or deportation order. However, if the INS denied a SAW application, the applicant could appeal to an administrative appeal board. The Haitian Refugee Center, another refugee organization, and 17 aliens whose SAW applications had been denied filed a class action against the INS in federal district court, arguing that the SAW program's procedures violated due process and therefore were unconstitutional. The INS argued that the Reform Act's channeling provision prevented judicial review of the SAW program's procedures generally. The district court rejected this argument. The district court then made a preliminary finding that the SAW program was being administered in an unconstitutional manner and entered a preliminary injunction ordering program changes. The INS appealed. The 11th Circuit affirmed the district court's rulings. The United States Supreme Court granted cert.